Hi, this is Harry Margolis. Welcome to Mass Health Planning, our next lesson in Estate Planning 101. So what's Mass Health Planning all about? The reason we conduct Mass Health Planning is because Mass Health, which is the Massachusetts Medicaid program, pays for nursing home care and in some cases also pays for assisted living and home care, though the rules are a bit more complicated for those and the coverage is somewhat more limited. So our discussion today is really going to be focusing on nursing home eligibility for Mass Health, which is very important since nursing homes these days cost $15,000 a month or more. And unless you're pretty well off, you can't pay that for very long. And if you're a married couple and one spouse ends up in a nursing home, it can end up bankrupting the other spouse unless they do some planning. And the only program other than private long-term care insurance, which few people have, that pays for this care rather than paying for it out of pocket is Mass Health. And it's become the long-term care insurance of the middle class. So how you qualify can be very important. So this is going to be a pretty, I would say, bare bones or high in the sky view of all these rules because they can get very complicated in specific situations. But the basic rule is in order to be eligible for Mass Health, you may only have $2,000 in what they call countable assets. If you're married, your spouse who's living at home, and they call it him or her, the community spouse, may have $128,640. So together you can have about $130,000. The house is the principal asset that's not counted against this limit. So you can keep your house and still get Mass Health coverage. And there's a limit in the value, the equity value of the house currently of $893,000. So if it's more than that and you're a single person, you either have to sell the house or borrow against it to get the equity down to that level. If you are married and the healthy spouse is still living in the house, then there actually is no limit on its value. The healthy spouse can continue to keep it. So those are the main asset rules. Then there are two other important rules to know about. The first is the transfer penalty. And what we have here is 5-year look-back period. And it gets complicated, but if you transfer assets and within the following 5 years, you apply for benefits, for nursing home benefits, then you will be deemed ineligible for a period of time based on the value of what you transferred. The higher the value or the higher amount of money you gave away, the longer the ineligibility period. But because of some complicated applications of the rule, you should probably figure if you transfer an asset, you're not going to get Mass Health for the next 5 years. You're not going to get nursing home Mass Health. You still might be able to get community benefits. So think of that's the 5-year look-back period. So if a transfer occurs more than 5 years before you apply for benefits, you actually don't have to report it. The other major rule of Mass Health, what we call often they don't get you coming, they get you going, is that after you passed away, the state has the right to recover whatever it spent on your care from your probate estate. And that's called estate recovery. And for most people, because the only principal asset or major asset they can still have and get Mass Health, we're talking about the house. So if the house ends up in your estate, when you die, the state can get its money back in most cases. There are a few exceptions. So a lot of our planning has to do with protecting the house. So there's two different ways of looking at planning, or two different times when you would plan. And one is advanced planning. So you're healthy, you figure you can wait out the 5-year look back period, you want to preserve some assets, and that's what we call advanced planning. And then there's crisis planning. And crisis planning is the time has come when you need care or your family member needs care, and you're probably facing a lot of other issues at that time, but one of them is how are you going to qualify for Mass Health sooner rather than later. So with advanced planning, the main parts of advanced planning are transferring assets, and you can transfer them outright as a gift. You can use an irrevocable trust, or you can transfer assets or your home. You can transfer your home into what's called a life estate. Now, outright transfers is the cleanest way to go. It's pretty simple. There may be some tax implications that complicate it, but it works easily. But the problem with it is if you give away assets, you don't have them. And we always counsel people, if they're going to give their assets to their kids with the idea that the kids are going to hold them for them if they need them, don't count on it. Not that your kids are bad, but things happen. People get into financial trouble, they get sued, they get divorced, they pass away, and everything passes to the surviving spouse. Things happen. So those are risks. Or you transfer to your 3 kids money equal amount to all 3, and one of them spends it and the other 2 don't, and they resent the first one for the rest of their lives. That's not a good outcome. But depending on the circumstances, you may still want to do that. The other is an irrevocable trust. An irrevocable trust protects against all those issues I just talked about, but it's a little more complicated. And it can be harder to get the money back if you need it, because irrevocable needs irrevocable. So if you put either your house or assets into an irrevocable trust, you got to think of it as a lockbox. There might be some safety hatches in it, but think of it as a lockbox. We often use irrevocable trust to protect homes because it's not a liquid asset. So you're not as likely to want to sort of break into that lockbox while you're alive. A life estate is a simpler way to protect your home. A life estate is a deed of the home, usually to your children, while on the deed you retain the right to live there for the rest of your life. So this means your kids can't kick you out of the house. They can't sell it from under you. If they get into financial trouble, the house still won't be sold out from under you. And there's some tax benefits that occur when the house is, when you pass away and later on they sell the house. The main drawback of a life estate is that if you were to go to a nursing home and at that point your family were to sell the house, you would get back some of the proceeds and have to spend that down on your care. So all these are tools, and different strategies make more sense for different people in different situations. So they're all to be discussed with an elder law attorney. So that's the main overview of advanced mass health planning. Getting to crisis planning, it's more difficult if you're single than if you're married. So if you're single, you're probably going to have to spend down your funds, but there are a few things you can do. So if you have what's called a caretaker child, you may be able to transfer the house to them. A caretaker child is defined as a child who has lived in your house for at least 2 years before you go to a nursing home, and during that 2 years provided you with sufficient care to prevent you from going to the nursing home for those 2 years. So it's a combination of factors, and where it works, you can protect your home by making that transfer. And it's certainly that exception is in there as an incentive to get people to care for the parents. You can also make transfers, transfer your home to a child who's disabled, or you can transfer either your home or any other property into a trust for the benefit of anyone who is disabled. So if you have a grandchild who's disabled or child, you can transfer your property, whether it's your home or other property, into trust for their sole benefit without a transfer penalty. So you can do that the day before you go to the nursing home or even when you're already there. And finally, there's pooled trusts, and this is an exemption that has been threatened but still exists. You can transfer assets into what are called pooled disability trusts, or D4C trusts, which refers to the statute that authorizes them. And there are a number of nonprofits in the state that operate these trusts for a lot of different beneficiaries, and the funds will be held in trust for your benefit during your life. So that's the great benefit of these trusts. So whatever you may need in addition to what the nursing home or assisted living facility provides can be paid from this trust. It's not a good tool, however, for saving assets for your family, because when you pass away, the state has an estate recovery right against the trust. So they get paid first, and only if there's money left over would that go to your family. Now, as I said, if you're married, there's a lot more protection. So first of all, as we discussed before, your spouse can keep almost $130,000 or about $130,000 in countable assets plus the house. In addition, the main technique for protecting additional assets for a spouse is what's called an immediate actuarially sound annuity. And that immediate annuity is one that's paying out immediately. And a actuarially sound, it's difficult to say, a little difficult to define, but it's some rules in MassHealth that say if the annuity meets these rules, then it won't be, your purchase of it will not be considered a transfer of assets and causing a penalty period. And just to say a few words, what's an annuity? An annuity is a contract with an insurance company where you give them a certain sum of money and they agree to pay back, basically pay back plus some earnings over a period of time. And that period of time may be a fixed number of years, say 5 years, or it may be for your life. For these purposes, we usually want to use as short term as we can and still meet the MassHealth requirements. And so that's a very good way of protecting spouses and nursing home residents. Finally, another thing that married couples should always do is if one is in a nursing home, is make sure all the assets end up in the healthy spouse's name. Because remember, the unhealthy spouse has to spend down to $2,000, but we also want to get the house out of his or her name, even though it could stay in the nursing home spouse's name, because the healthy spouse could die before the nursing home spouse. And so we also want the healthy spouse to change his or her will so that if he or she dies first, everything doesn't go back to the nursing home spouse and have to be spent down. The community spouse or the healthy spouse can create a trust in his or her will, what's called a testamentary trust, for the benefit of the nursing home spouse, just to make sure there are assets there to take care of him or her if necessary. So that's a very quick course on a very complicated topic, MassHealth planning. We have many additional resources on our website at www.margolis.com. And also, if you have any questions, you can either post them on my other website, www.askharry.info, or give us a call or send us an email. Thank you.